Father against Worcestershire County Council.
The judgment in this case is being handed down now. We're distributing hard copies in the court. A copy of it will be posted on the court's website as well. Thank you. Lord Stevens will explain the judgment.
This appeal raises important questions in relation to the interplay between the habeas corpus procedure, under which a person's release from unlawful detention may be obtained, and the procedures in the Children Act 1989 concerning child protection arrangements made under a care order. In relation to the procedures under the Children Act, a care order authorizing child protection arrangements can only be made if A, the child is suffering or is likely to suffer significant harm, B, that harm is because the care given to the child or likely to be given to him is not what it would be reasonable to expect a parent to give to him, and C, the arrangements are in the child's best interests. This appeal concerns two children who have been placed in the care of Worcestershire County Council under a care order made by a district judge in the family court. The care plan is for the children to live together in the long-term foster care with the same foster parents. In making the care order, the district judge decided that the threshold of harm and its attribution had been met, and it was appropriate to make a care order. The decision of the district judge to make a care order was a first instance decision, and the father could have appealed against the care order to a higher court. He did not do so. He can still apply to appeal out of time, but he has not done so. Furthermore, under the Children Act, the father could have applied and can still apply to set aside the care order. He has not done so. By comparison with an application for habeas corpus, there are obvious procedural advantages for the children, the father, the council, and the court of a challenge to the care order by the process of an appeal or by way of an application to set aside the care order. The father would be a party to the proceedings, as would the council and the representative of the children. The court would have the advantage of hearing submissions from all the parties aimed at securing, as its paramount consideration, the welfare of the children. Rather than challenging the care order by way of an appeal or an application to set it aside, the appellant has commenced these habeas corpus proceedings, asserting that his two children are subject to detention by the council in their foster placement and seeking their release. The High Court dismissed the father's application for habeas corpus on the basis that the correct process was for the father to appeal the care order, and applying for a writ of habeas corpus was inappropriate and wrong. The father appealed to the Court of Appeal, which also dismissed his application for two reasons. First, the father's application was not the correct process, and second, the children were not detained. The father now appeals to the Supreme Court, which unanimously dismisses the appeal for the reasons set out in a joint judgment given by Lord Sales and me, with which the other justices agree. I will now briefly summarize the reasons. First, and quite simply, the children are not being detained. Rather, they are simply living with foster parents in exactly the same type of domestic setting as any other children of their ages would be, whether living at home with their parents or staying with friends. That is not detention. And because they are not detained, there can be no question of any court ordering their release from detention. The appeal is therefore dismissed. Second, in extreme or unusual circumstances, the improper exercise by the children's foster parents of the parental authority delegated to them by the council could amount to unlawful detention. For instance, foster parents locking children in their bedroom for a month would result in the deprivation of the children's liberty, amounting to to detention. However, there was no allegation of any extreme or unusual circumstances in this case. B, as there was no such allegation, the application for habeas corpus failed to be dismissed on a summary basis. On that basis also, this appeal is dismissed. I would add that if there was an allegation of extreme or unusual circumstances, then an initial judgment would have to be formed as to whether the application based on that allegation had any real prospect of success. If it did not, then the application for habeas corpus would fall to be dismissed on a summary basis. In forming an initial judgment as to whether the application based on that allegation has a real prospect of success, the court should consider the comprehensive set of obligations which are imposed on several individuals to ensure that the child is properly looked after and the arrangements for monitoring those obligations. There would have to be failings by several individuals before there could be any really realistic prospect that an applicant for habeas corpus could establish extreme or unusual circumstances. It should also be appreciated that if a court finds that there are extreme or unusual circumstances so that a child is unlawfully detained, the court will order release from detention. It does not set aside the care order, so the child will not be removed from the care of the local authority. Third, we have considered what the position would be if, as the father alleges, the care order did authorize the detention of the children. In such circumstances, the care order would provide authority for the children's detention. Therefore, to succeed, the father would have to either successfully appeal against the care order or successfully apply to set it aside. Both of those routes are available to the father and do not require any application for habeas corpus. However, if the father relies on habeas corpus, he would have to bring judicial review proceedings in aid of the habeas corpus application to quash the care order. An applicant for judicial review must obtain permission to bring those proceedings. Permission would not be granted if there was an adequate alternative remedy. In this case, there are adequate alternative remedies in that the father can seek to appeal against the care order and can apply to set it aside. The father ought to have challenged the care order by one of these means rather than by an application for habeas corpus. As I have indicated, the appeal is dismissed, but I would make two further points. First, the father has conducted the care proceedings and the application for a writ of habeas corpus without legal representation. We pay tribute to the polite way in which he presented his appeal in this court, and we acknowledge his concerns about his feelings for his children. Secondly, the remedies which are available to a person in the position of the father of an appeal against the care order or of an application to discharge the care order are carefully calibrated to protect children, either by ensuring that they are returned to their families or by ensuring that they are not exposed to significant harm. The procedures to be followed in the family court in applying for such remedies have also been carefully worked out to ensure that the court is able to establish what are the best interests of a child as regards where or with whom the child should live. In conclusion, the appeal is dismissed.
The court is now adjourned.